Thank you. Can everybody hear me okay? Okay, great. I really want to thank Dr. Jarvis for his kind invitation. It's been an honor to be with this very, very illustrious group. I know Anita mentioned at the beginning that she felt almost like she had to apologize for being an accidental forensic linguist. I'm not a linguist at all, so there's my apology. I'm actually coming to you from the world of interpreting studies, and more concretely, I work in testing and credentialing. So before you start snoozing, things actually will get a little more interesting than just talking about interpreter testing. But I did want to thank Dr. Jarvis and everybody that helped to make this such a fantastic experience. And thank you to our two ASL interpreters. I'm usually the one interpreting, so having someone interpret for me makes me feel very, very glamorous. So anyway, thank you very much. So in today's session, I wanted to cover maybe some assumptions that we may have in common very, very quickly. As we go through our conversation today, I'm going to ask you to just take my word for a few things so that we can progress along. So we'll talk about some probably shared assumptions and go over some barriers to identifying and recruiting and certifying qualified court interpreters. And then we'll talk about what certification actually means. That's really the crux of the talk today. So we're going to talk about what it means when you have a certified interpreter in your courtroom. And I don't think anyone from the judiciary is still here. Is that correct? Do we have any attorneys or judges or law enforcement people here anymore? Okay, so a couple. So you're going to feel a little singled out because a lot of the aspects of my talk today are kind of directed towards stakeholders in the justice system. And then we'll do a few conclusions and recommendations. That's the part where I get really preachy and tell you what you have to do next. So I should warn you, my students always love to have a trigger warning. So the trigger warning here is that this conversation is going to become a less happy conversation as we go through the next couple of slides. And I should tell you why. My whole research trajectory, or most of it, has been focusing on how you accredit translators and interpreters, how you determine that they meet a minimal threshold in order to practice and provide service of a certain amount of quality. So I've always been a person who advocates very strongly for certification, and I still do, and I always will. But this whole presentation is about all of the problems that you might find when you work with certified interpreters. So this is the secret presentation that I never share with practitioners. So I feel, kind of shrouded in guilt for talking about some of these issues. But I think the more you study something and examine it closely, out of love, you also are compelled to talk about the deficiencies. So talking about some of the common ground and the shared assumptions. Those of us who work in the justice system probably agree that there's a burgeoning emphasis on issues of quality assurance in interpreting and in language access. This is especially salient and obvious in the European context, where after the passing of the European Directive 2010-64, which guarantees, in theory, quality translation and interpreting in criminal proceedings for the 28 member states. That has led to a lot of changes on the ground in the member states to try to harmonize their systems and create mechanisms whereby interpreters and translators can train and accredit and prove that they can provide quality services. So all of this is to ensure mutual trust, which is kind of a buzzword that you hear in the European context all the time. But of course in the United States, where we essentially have 50 jurisdictions plus all of our territories, we also have the need to talk about issues that foment mutual trust. So quality in language access is a very important issue in research right now. We know that there are a lot of barriers in identifying and recruiting and credentialing interpreters, and we're going to very quickly run through some of those barriers. But I think we all can also agree on the fact that certifying competent interpreters is really key for due process. I think we all agree that you cannot participate in your own defense if you can't understand the accusations that are being made against you, and you can't make yourself understood. So let's talk really briefly about some of these barriers. There are actually about 1,000 of them, but I'm going to reduce it to 2 slides. Some of the big ones, again, I'm sure this is shared ground, but a lack of compliance with existing language access legislation. That's where we have laws in place that guarantee language access, but nobody heeds those laws. There's a lot of difficulty in identifying and training and recruiting qualified interpreters. This is especially true with speakers of languages of limited diffusion. And I come from a perspective of Spanish, English, spoken language interpreting, and so all of the things that I'm complaining about are literally 1,000 times worse for smaller languages. We all also know that there's a rampant use of ad hoc interpreters in the justice system as well, even in places that have statutes that prohibit it, which are very few and far between. But we still hear the stories about the cleaning personnel being pulled in, and the nice lady from the library across the street, and the family member. And this still happens all the time, even where I live in Texas, where there are many presumably bilingual people. There's also a reluctance to pay. This is something nobody wants to ever pay for because they think anybody could do it. I'm sure you're all familiar with those attitudes. And so that leads to a lack of political will and administrative action. Then there's the more common, I'm thinking in Spanish here, the practice that's becoming increasingly more common, which is to outsource. So stakeholders in the justice system don't know what they're getting. They're getting people who are sent from agencies who we don't know if they've been vetted, we don't know if they've been trained, we don't know if they've been credentialed. And so that creates problems within the realm of professionalization. Talking about testing, there are also certification schemes, and when I say scheme, I don't mean it in the fun way, I mean a certification system that includes testing, training, accreditation, administration, security, and all of the things that go with that. But there are models that simply aren't psychometrically normed models, or they're not scientifically sound models. That's a problem. Then there's the thing that nobody likes to talk about, which is the systemic racism and the anti-immigrant sentiment that is still really pervasive. There are problems with exam construction, especially when you can't find enough subject matter experts in a given language. You can't find enough people to test your exam items with. You can't find enough people to train as raters. That's another constant problem. There are problems with exam administration because there have to be protocols in place to make sure that rating is consistent across all languages and even across raters. There are inconsistent security protocols. I promised you there would only be 2 slides of barriers, and so I'm going to stop now, but I mean, you're getting the picture, I think. So then we have to talk about certification for a moment. The idea with certification, and I should tell you what I'm talking about here. I'm talking about spoken language court interpreter certification at the state level, because there is a federal level. The state level is what I'm talking about because it's the most common gateway to the profession, and it's what's really happening on the ground every day in municipal and district courts and circuit courts all over the country. So the National Center for State Courts has a big test bank in 20-some languages, and they share these exams, and they're all based on, I'm simplifying a lot, but they're all based on a certain model. But I think we can agree that certification is something that it signals quality, because it tells you this person passed this exam. That means this person can do something. So exactly what can this person do? That's kind of what we're going to talk about a little bit. Exams in the United States for court interpreters in spoken languages are totally performance-based. So that means that in theory they're task authentic, because what you're doing on your test is interpreting simultaneously, consecutively, and in sight translation with authentic discourse. And in fact, the consortium, or the National Center for State Courts model, has been shown to have been psychometrically normed and to have the kinds of validity that are always talked about in testing theory. So this model does enjoy face validity, it does enjoy content validity, construct validity, concurrent validity. The conversation about using principles of testing theory to talk about this exam model is another conversation, which we can leave for another day. It's a really juicy one, believe it or not, but we're gonna leave that for another day. So certification is important, but here's the question: what does certification really guarantee? So what level of quality can stakeholders in the justice system assume or expect when they hire a certified interpreter? Recall when I asked you this question that most of the interventions by interpreters in court don't happen with certified interpreters at all. So in those situations, of course, our questions are even more copious, right? There we really don't know anything. But I wanted to reiterate the fact that I'm a huge proponent of certification for court interpreters. I speak to academic audiences and I speak to professional audiences, and to the practitioners, I'm always talking about the importance of certification, because it's a step toward professionalization and it is a signal of something. But now the news is going to get worse, so let's talk about what a certified interpreter in your courtroom does not guarantee. So there's a big body of research, huge, that talks about the qualities of both the knowledge, the skills, and the abilities that interpreters in legal situations should have. So this is where I'm going to ask you to just trust me. I've done all the reading and the compiling, so just trust me. I'm sure there are many, many more that we could talk about. But when a court interpreter does an oral exam, their exam is graded based on scoring units. Scoring units are these kind of discrete elements that interpreters should be able to correctly interpret. And they're things like numbers, names, idioms, legal terminology, general terminology, modifiers. There's a lot of different kinds of categories, right? And so the graders are looking for whether or not your rendition is an acceptable equivalent for the thing that's underlined in the exam. So typically, this model of exam covers a lot of things: listening comprehension, reading comprehension, speaking, listening, reading, because sight translation involves reading. But if you take a look at the column about the skills that are not assessed, that's actually what we're going to focus on. I hate to be negative, but we know that to be an effective court interpreter, besides all of these linguistic things that you're being tested on, it is really, it behooves us to also exercise situation control, to understand protocol, to have a decent grip on the home and the target legal system, and also to be able to make ethical decisions during your practice so as not to accidentally be practicing law, right? We have to go through life-making disclaimers as well. The three things that you see in red, let me talk about those really quickly. So there are some speaking and listening skills that are actually not tested or not assessed on the consortium exams. So I thought it was interesting that Keith talked about accent discrimination, because actually on these exams, your accent cannot count against you. That's why people in the judiciary sometimes are floored by the impenetrable accents of some of their interpreters. It's because it's considered to be so subjective that they're not allowed to evaluate it. It's off the table. And then there are all these soft skills and dispositional traits. So soft skills are kind of those intangible things that help us to thrive in a workplace. And then all of the communicative and interpersonal and intercultural elements. So it's very, very hard to test all of these on one set of exams. So that's why we're going to go a little bit quickly through the next 3 slides. These are the speaking skills and the listening skills that are not assessed. And the reason is because the consortium considers that these elements are simply that they can't be measured through objective scoring. and they only want to rely on objective scoring. So all of these kind of prosodic elements that involve things like delivery criteria, fluency, intonation, even a pleasant voice or a native-like accent, all of these constructs are considered so intuitive and so subjective that, as we said before, they're completely left off the table. Then there's also a lot of consensus about the intellectual and dispositional competencies that court interpreters should have. None of these are assessed. And we can see why, right? Because the way the exams are construed or constructed now, there's just no way to do it. But I want to call your attention to a couple of them in the first column. So things like cognitive flexibility, this is something that comes from age and time on the planet and education, and you're a product of everything you read and everyone you talk to and every place you've traveled and everything you've been exposed to. And part of that is formal education, even though in the interpreting community there's a big backlash against talking about formal education. So, but I guess I would say, I'm biased because I do believe that there's value in having a theoretical underpinning that can inform your practice, if only because it makes you more reflective as a practitioner, and it gives you a knowledge of the theories that actually help you describe with appropriate meta-language what it is that you're doing. These are good qualities in an interpreter, especially as we're seeking visibility and development as a profession. Then there are all these communicative and interpersonal sorts of qualities that are not assessed. So one thing that I would say is, in a perfect world, and this is for another conversation, trust me on this, please, if we could combine these kind of performance-based exams that have been normed and tested and are scientifically reliable to some extent, we can complain about those too, if we could combine all of that with kind of a competency-based instruction and assessment method, which would involve ongoing formative assessment and actually training court interpreters, because nobody gets any training, we're just thrown to the dogs. I have a whole article that is Melissa's dream about how we would actually combine methodologies to test and train court interpreters in a perfect world. But we can leave that for another day and maybe just hop to some of the conclusions because of time constraints. So this presentation has really been quick and dirty, and it's aimed to articulate this disconnect between what the judiciary expects from certified court interpreters, and here I'm talking about the knowledge, the skills, the abilities, the attitudinal traits, all of it, and what certification might actually guarantee these court stakeholders in terms of a minimal level of competency. So take a look at the first bullet, which talks about the scarcity of training, and many of you know this. Well, maybe you don't know this, I don't know. In a 2010 study of Wisconsin court interpreters, 95% of certified interpreters said that they self-trained for the certification exam. And that was a long time ago, that was 8 years ago, and that was in a very rural state. But anecdotally, I hear this everywhere, that there's a lack of training. And then when court interpreters can find training, it's training that is dubious because, I don't know how you'll feel about me saying this. Some people accuse me of having an elitist attitude, but I want my training to be research driven. And I want my training to come from people who can tell me why they're saying what they're saying. I don't want it to be, there's a lot of value in getting training from people who have a lot of experience, but there's also a huge body of evidence that says that accuracy and quality don't come from experience, they come from training. So I would like to see a little bit more consciousness raising about that. In order to take the exam sequence to be a certified court interpreter, there is no educational requirement. You don't even have to have a high school diploma. And so Dr. Eggington mentioned this morning, and I hope I don't say this wrong, you talked about the fact that people with a low level of studies often can't navigate high registers, which is normal. But I guess what I'm trying to tell you is even people who are not non-native speakers of English, as we've seen from Anita's project, also cannot sometimes navigate high registers. That's something that formal education can help with. You know, you may or may not agree with me on that, but I'm right. And then there's delivery, sorry, my students like it when I'm snarky, but I know this is a different audience. So also delivery-related competencies and substantive knowledge. These things should be taught, even if they're still not assessed. They don't show up on the exam, but they're important. We have to contemplate them. And then there's that little seed that I wanted to plant about a possible new model that includes competency-based assessment and training. So in terms of testing and credentialing, again, I will just say that if we could think about developing this kind of hybrid credentialing system that would combine the best of both of these worlds, something that's more complete and more nuanced really would give us more information, and it would make certification mean a lot more than it does now. So because I thought many of the people were going to be from the judiciary, I thought I'm not going to give you an academic ending. I'm going to give you Melissa's wish list. So here it goes for those of you who are here. I would ask our colleagues and our counterparts in the justice system to develop a sensitivity to and an appreciation for the essential role of the interpreter. They're referred to. A lot of my colleagues have said these are instances in which an interpreter would have solved the problem. Not necessarily, that's the problem. But you have no better option, so yes, call an interpreter. So we also have to understand that interpreters can really be our allies when communication breaks down, even in an adversarial system like the justice system. I would ask my colleagues to understand that your interpreters in your courtroom could be anyone. And what I mean is, and this is anecdotal, people make assumptions about interpreters, especially because they're often brown and they have accents. And so a lot of people in the justice system already have some preconceived ideas about who these people are and their level of education and their level of formal training and their professionalism and their skill level. So I would ask that we all keep an open mind. And at the same time that we advocate for translation and interpreting studies to have a place in higher education so that we can begin to raise our research profile and our profile as professional practitioners. And finally, this was going to be for the judges in the audience. Now there aren't any, but I would say ask your interpreters to be very explicit on the record about their credentials, their training, and their education. Training and education I separate out. We can talk about that if you want, on the record. So with that, thank you for your kind attention. If you have any questions, I'd be very happy to answer them. Thank you.